Sam continues his presentation on wills and trusts.
We are just not big on revocable trusts, with this caveat, okay? That is, in very large estates, it can be a big benefit, okay? In very large estates. Does anyone in the room feel like they're going to be bumping up against the $10.9 million cumulative exemption? The answer normally should be, not yet, right? Okay, but the point is, in very large estates, okay, this does have a benefit. In our opinion, you're best served by having a will that directs clearly and appropriately what you want to have done. So the will gets presented to the judge, and the judge is looking, yes, ma'am.
So on this irrevocable trust, and I'm asking because
No, wait a minute, you said something. You said irrevocable
No,
trust.
sorry, revocable.
Revocable trust.
Sorry. So I'm a trustee. A friend of mine has, if I understood her right, she put her house in a revocable trust. Can you do that?
Yeah.
So real, but then, so what does that mean for the trustee? What do they have to do then with said house?
It depends on what the trust says,
Okay.
because then the trust controls how the house is distributed. Now, the reason I say yeah is because that is becoming a very popular planning technique. And quite honestly, it clouds title when you go to sell the house, and there's lots of issues around it. But to the extent people want to do that, you can do that.
It just doesn't, from your perspective, it just doesn't make sense.
We believe that simple is almost always better.
Okay.
Occam's razor. The simplest answer is normally the best.
Okay.
When the will's presented to the court's looking for two things. Court wants to know, number one, is it properly signed? I mean, is it a valid will? Does it have two witnesses? The second thing the court wants to know is an executor appointed? The executor has two prompt issues to resolve. Number one, the executor makes an accounting to the court of all your stuff, all your assets. That includes joint, separate, etc., everything you own. That becomes an inventory. The second thing the executor does is notifies creditors. Both creditors you know about, the guys that are sending monthly bills, as well as you publish notice to give people an opportunity to make a claim in the estate. The other people that get notice are your heirs. All right, somebody that would otherwise get an opportunity to argue against the will. We've had situations where people want to disown children. Most of the time, it's for valid reasons. Every once in a while, we have a very elderly person come in and want to disinherit one of their children. And in those cases where it's a disinheritance by a very elderly person, in this case it was someone over 87 years old, we ask for a psychiatric evaluation so that we have a piece of paper in our file that says, yep, you know, Sally was right as rain. That's exactly what she intended to do. She did it. It's all good. And I don't have to look at Judge Block and have Judge Block ask me, and Sam, why did you think you were capable of deciding whether she was competent or not? One of the beneficiaries you cannot disinherit, however, is a surviving spouse. Even if you say, I want nothing to go to my surviving spouse in your will, the law provides that a surviving spouse gets a statutory share, which is 1/3, okay? So you cannot disinherit a surviving spouse. After the will is admitted, after the inventory, after the notice to creditors, comes now the taxes. There are 3 types of taxes which are applicable to an estate. One is a federal tax. It's a federal estate tax, okay? And that federal estate tax is on single estates over $5.49 million, and that federal estate tax is on single estates over $5.49 million, and that federal estate tax is on single estates over $5.49 million, and that federal estate tax is on single estates over $5.49 million, and that federal estate tax is on single estates over $5.49 million, and that federal estate tax is on single estates over $5.49 million, and that federal estate tax is on single estates over $5.49 million, and that federal estate tax is on single estates over $5.49 million, and that federal estate tax is on single estates over $5.49 million, and that federal estate tax is on single estates over $5.49 million, and that federal estate tax is on single estates over $5.49 million, and that federal estate tax is on single estates over $5.49 million, and that federal estate tax is on single estates over $5.49 million, and that federal estate tax is on single estates over $5.49 million, and that federal estate tax is on single estates over $5.49 million, and that federal estate tax is on single estates or combined estates of just a little bit closer to 11, okay? Again, most of the time, for most of our clients, the estate tax doesn't apply. The second type of tax is an inheritance tax. Inheritance tax is an Iowa tax, and it's a tax based on who the beneficiary is, okay? There is no inheritance tax on a spouse or a lineal ascendant, parent, grandparent, or lineal descendant, a child, grandchild, and also included in that are stepchildren, step-grandchildren. So most of the time, there isn't an inheritance tax. So what kind of tax is everybody worried about? Well, arguably there's still an income tax. The government, they get you coming and going, right? As George Harrison taught us in the song Taxman, be clever, put pennies on your eyes. The point is that when someone passes, their income tax year ends and the estate's tax year begins. Okay, and the estate has its own income and the estate has its own expense, so it files a tax return. After the tax returns are filed, the Iowa Department of Revenue waves its hand, says good, you're good to go, and issues an acquittance. Upon that acquittance, you can start distributing to creditors, you can start distributing to beneficiaries, and close the estate. In closing the estate, that's where the trust comes in for the grandchildren. Okay, instead of distributing to the grandchildren, if you're going to have a trust, that's where the distribution goes to that trustee. The trustee will invest the money on behalf of the grandchild. The trustee will expend the money on behalf of the grandchild to the extent that it's appropriate. What's appropriate? Education's appropriate. Health insurance, health care is appropriate. Reasonable living expenses are appropriate. We don't want you to, be squandering money, but reasonable living expenses. That trust is the trust that I talked about earlier, and we recommend the trustee for that be a bank. And the reason for that is you don't want your grandchildren angry at their Uncle Mike. You don't want those grandchildren having a family problem because of money. Money turns out to be something that can be very divisive within a family. Banks should be the trustee. The trust ultimately has to distribute its funds, and it distributes its funds on specified periods. Age 25 and 30, 35 and 40, some specified period. And ultimately, it's used for the benefit of the beneficiaries or distributed out as a principal distribution. Included in your materials is some things that we have found to be common estate plans. I'd like to draw your attention to the single. I assume that we have some singles in the room. Is that a correct assumption? Okay. For singles, what we normally find is they want some to go to family members and oftentimes some to go to charity. That's not always the case. We are big believers in charity, and to the extent someone wants to do that. We've had single individuals come in and want to set up scholarship funds, whether those scholarship funds are at a university or at a school. We do those, but we kind of recommend, if you can, have someone else do that. I mean, if there's already an athletic scholarship at the University of Iowa, contribute to that rather than trying to create your own. But to the extent we've done some foundations in estates. Married with children. I thought that was a ridiculously stupid television show. Did anybody else like it? If you're married with children, normally what we find, is that people want to make a bequest outright to the surviving spouse. And they say, well, the surviving spouse will take care of the children or the grandchildren. Because most of the time, they are children of the deceased. I'll talk about what happens if not in blended families in a second. When the passage of the surviving spouse happens, then it goes to the children, or if one of the children does not survive, to a trust for the grandchildren. Increasingly, we are seeing blended families, however. Okay? Now, what we have been seeing in blended families is most of the time the surviving spouse is the primary beneficiary. Okay? And what we are seeing is that either it's all to the surviving spouse or at least a big percentage to the surviving spouse. Then, in blended families, people want to take care of their biological children. So oftentimes, if it's not to the surviving spouse, it'll go to their biological children or some form of division between their biological children and their spouse's biological children. You know, maybe they've been married long enough or they like the kids well enough that they say, they're all our kids. Whether we've adopted them or not, we want to treat them all like kids. We have seen more different ways than you can possibly imagine, and you can be assured that I would never tell you, nor would I tell anyone else, what somebody's actually done, okay? Because that's a private matter, and again, what people feel they should do for their family is up to them. It's not up to me. And we've seen lots of different situations and cases. People sometimes ask about will contests. We've done them. There are basically two grounds you do them on, either undue influence or incapacity at the time of the will. I will tell you these are big uphill battles. These absolutely destroy the family. And as it turns out, these are very expensive because what you're doing in court is trying to prove the psychological ability or disability of somebody who's not there. You need all kinds of experts, you need all kinds of witnesses, it's an extended trial, and I can assure you a will contest destroys the family. Okay? Having said that, if it's appropriate, it's appropriate. If somebody has overreached, they have overreached. And we were successful in recovering $6 million worth of assets for the children of a deceased fella whose will was changed 8 days before he died by a lawyer who represented his brothers, and his brothers got all the assets instead of his children. Okay? Stuff happens. Albert Einstein once said, the universe isn't just queer, he said, it's more queer than you can possibly imagine. Our finding is people are the same way. People do strange things. Moving from that,
Steve, are these the only 3 plans you have? Common estate plans for single, common estate if you're married with children or married with blended? I mean, do you have married with no children?
absolutely. And what we tried to do in today's presentation is just to provide you with what we see most commonly. Quite frankly, we've seen every way you can possibly imagine. We've seen cohabitation with children, cohabitation with adopted children. We've seen married with no children. This presentation is designed to give you an overview rather than to give you a plan. So there's lots of different ways to do estate planning. Now, what if you don't have a will? And then I'm going to talk about powers of attorney. If you don't have a will, the law drafts one for you, okay? And basically what the law provides is if you're married, again, you can't disinherit a surviving spouse. But if you're married and all of your children are also the children of your spouse, spouse gets everything, okay? So I'm married to Lori. All of Lori's children are also all of my children. All of my children are also Lori's children. Lori gets everything. If you're married and some of the deceased children are not the children of the surviving spouse, then the surviving spouse gets half and the children of the deceased get half. So if I had children from a prior marriage, okay, they would get half and Lori would get half, surviving spouse. Now, what if there's no children? Well, if there's no children, then you get the situation of the surviving spouse getting it all. What if there's no children and no surviving spouse? Therein lies the big question. And I tell people it's like a fountain, okay? If there's no children, no surviving spouse, then the parents of the deceased get. If there's no parents, then the siblings of the deceased get. If there's no parents and no siblings, then nieces and nephews get. And it becomes sort of like a waterfall. If there's no nieces or nephews, then you go up to the grandparents and you look for grandparents' relatives, okay? The point is, this has very little flexibility and, quite honestly, doesn't normally reflect what our clients would want to have happen. Now, sometimes it's okay, okay? And oftentimes it's okay when somebody has no estate, right? If the creditors are going to get it all, you don't care. But by the same token, we would tell you that if you do have things you care about, if you do have assets that you want to go to your family, you should take control. You should decide how it goes, not the statute. Statute's not bad. Statute was adopted so that people would stop fighting over assets, because that was the tradition. The tradition was the families would fight, okay? But if you want to take control, you need to have a will. You need to have counsel. You need to do what's right for you and for your family.
Part 3 of the Kreamer Law Firm seminar on wills and trusts is just ahead.